Hello, my name is Sarah Dinson. I'm an accredited representative at the North Suburban Legal Aid Clinic. In this presentation, we'll be covering two specific types of immigration relief available for survivors of domestic violence that was perpetrated by U.S. citizen or lawful permanent resident household members. I would like to begin by introducing our organization. The North Suburban Legal Aid Clinic provides pro bono legal services in the areas of domestic violence, housing, and immigration. We currently provide services to clients in Southern Lake County and Northern Cook County. For our immigration and housing cases, we're able to assist individuals with income at or below 250% of the federal poverty level. We do not have any income threshold for our domestic violence legal assistance. This chart depicts various behaviors that constitute domestic violence. Importantly, this chart highlights the fact that domestic violence is not exclusively physical. It may also be verbal, financial, and psychological. Throughout this presentation, we're going to focus on immigration relief available under the Violence Against Women Act. The passage of this act created many of the survivors' assistance programs, organizations, and funding sources that exist today. Furthermore, the Act created two special paths to lawful status for survivors of domestic violence. The first type of immigration relief created by the Violence Against Women Act is called the VAWA Self Petition. Under general immigration law, a U.S. citizen or lawful permanent resident may submit a petition to immigration requesting lawful permanent residence for their spouse, child, or parent. Lawful permanent residence is colloquially known as a green card. This process is heavily dependent on the U.S. citizen or lawful permanent resident petitioner, who must provide personal information, signatures, and a document called the Affidavit of Support, which commits them to financially supporting the intending immigrant if need be. Unfortunately, in an unhealthy relationship, this petition process can create an imbalance in power, which allows the abuser to control and threaten the intending immigrant. The VAWA self-petition aims to provide relief to individuals in this exact situation. It does this by allowing the spouse, child, or parent of a U.S. citizen or lawful permanent resident to gain independence from their abusive family member by petitioning themselves. In addition to demonstrating that they are the spouse, child, or parent of a U.S. citizen or lawful permanent resident, VAWA self-petitioners must demonstrate that they are physically resided with their U.S. citizen or lawful permanent resident family member, and that they were subject to abuse or extreme cruelty at the hands of this person. In the cases of spousal abuse, the intending immigrant must also provide evidence that they were engaged in a good faith marriage that ended within the past 2 years. Evidence of each of the aforementioned requirements must be included in the VAWA self-petition, and some examples of evidence types are listed here. For VAWA self-petitions, any police reports and court documents that exist should be included, but they are not strictly required. Listed here are some examples of evidence that can be used to demonstrate prior cohabitation and a bona fide relationship. The second form of immigration relief created by the Violence Against Women Act is the I-751 waiver. While the VAWA self-petition is for those newly seeking lawful permanent residence, the I-751 waiver is for those who already have conditional lawful permanent residence and are seeking to remove the conditions on this status. If an individual is petitioned for permanent residence by their U.S. citizen or lawful permanent resident spouse, and they receive their lawful status before they have been married for a period of 2 years, they become a conditional lawful permanent resident. This period of conditional residency lasts 2 years, and at the end of those 2 years, both spouses must work together to submit an I-751 form attesting that they're still in a bona fide marriage. In abusive relationships, this joint requirement can be used to exert power and control over the immigrant spouse. In cases where the immigrant spouse was subject to abuse or extreme cruelty, the I-751 waiver allows that spouse to apply to have the conditions removed from their residency without cooperation from their abusive spouse. The 751 waiver is available to residents who have been subject to spousal abuse, which includes psychological and other non-physical forms of cruelty. The evidence required to document this abuse is very similar to that required in the VAWA self-petition, and also does not strictly require a police report to document domestic violence. If you believe that you or someone you know may benefit from speaking with one of our domestic violence or immigration attorneys, please call our clinic to set up an individual legal screening. It is also worth noting that there are more options for immigration relief available to survivors, such as the U visa and the T visa. We are happy to discuss all potential options available to survivors of domestic violence, trafficking, and other crimes. Furthermore, we encourage anyone with concerns over their immigration status to create a safety plan and to share that safety plan with an emergency contact that they trust. Lastly, we would like to remind you that only an accredited representative or an attorney may provide legal advice pertaining to immigration. If you or anyone you know has questions about immigration options or their rights as an immigrant, please feel free to contact us. Thank you so much for taking the time to listen to this presentation. I really hope that the information shared today will be helpful to you or someone that you know. Our contact information is listed here. Please do not hesitate to reach out with any questions that you might have. Thank you very much.